How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No, ma'am.
This is ridiculous. And we don't have punks like you acting like this and treating us this way when we're at our job. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the stage will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well.
Your Honor,
ahead.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
Honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that?
Yes, ma'am.
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No, ma'am.
This is ridiculous. These people are just going to work and trying to do their job. That's all.
Yes, ma'am.
You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device, and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738 to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
Jamayssha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a sentencing, for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you.
Stop right there. We are plunging into a courtroom confrontation that is already on a razor's edge. Mr. Hancock, 36 years old, is facing a terrifying stack of charges. Evading arrest, not once, but with previous convictions, and the highly serious continuous violence against the family. But the tension isn't just about his past. It's about his attitude right now. In a stunning display, the judge immediately puts him on blast, questioning why a 36-year-old man needs to be told how to behave in jail. This isn't just a hearing, it's a dressing down. The prosecution is armed with a history that makes your jaw drop. 10 prior felonies, including firearms and drug charges, and a staggering 7 prior evading convictions. And if that wasn't enough, he was arrested for a new evading charge while already out on warrant for the first 2 cases. This is a pattern of blatant disregard for the law, and the judge knows it. Hold on to your seats because the defense is scrambling, trying to explain away a missed court date and a bail bondsman pulling the plug. But when the judge finds out about jail incident reports detailing his threats and disrespect toward correctional officers, the temperature in this courtroom hits a freezing point. The judge's ultimate threat? 25 years to life. Watch as we break down exactly why this defendant's attitude just cost him his only chance at freedom. The ruling is coming, and it is going to be brutal. We have just witnessed a masterclass in judicial frustration and firm rule setting. This entire exchange was a stark reminder that the courtroom is a place for accountability, not insolence. Mr. Hancock, a man with a deeply concerning and extensive criminal history, 10 prior felonies and 7 prior convictions for evading arrest, attempted to seek a bond reduction. The defense, Miss Holmes, made a valiant effort, citing a hospital visit as a possible reason for the defendant's missed court date. But by the time she presents this information,
the ship has already sailed. This is a critical legal insight.
Once a defendant fails to appear, the bail bond is forfeited, and the court's priority immediately shifts from assuring appearance to ensuring public safety, especially given the new arrest while out on warrant. The AFRS, Affidavit for Revocation of Suretyship, filed by his bondsman was the first red flag, signifying that even the entity financially responsible for him no longer trusted him to show up. That action, combined with his missed court date, essentially cemented his bond forfeiture. But the true, dramatic turning point, the moment that seemed to seal his fate, was the revelation of the jail incident reports. For the defendant to not only be facing serious felony charges like continuous violence against the family, a habitual felony charge with massive sentencing implications, but also to be actively threatening and disrespecting correctional officers while in custody, demonstrated a profound lack of regard for authority and the law itself. The judge's powerful monologue, calling him out as a punk and reminding him that his rights to make decisions are gone, was not merely an emotional outburst. It was a calculated judicial strategy to impress upon him the gravity of his situation and to establish a clear judicial record of his disruptive behavior. This behavior is crucial because it directly speaks to the legal standard for setting and maintaining bond. Is the defendant a flight risk or a danger to the community? By threatening officers, Mr. Hancock provided undeniable evidence that he is both a danger and unwilling to follow even the most basic rules, making him an exceptionally poor candidate for pretrial release. The judge's ruling was definitive, harsh, and entirely predictable given the evidence. First, the motion for bond reduction on the two April cases, 25 DCCR 0737 and 0738, was flatly denied. The $100,000 bond stands. Second, for the newest evading arrest case, 25 DCCR 1233, the judge found the existing bond insufficient and raised it to $100,000. The final tally? $300,000 total in bonds. What's the legal implication of this? This high bond amount isn't meant to be paid. It's a mechanism to ensure his continued detention until trial, protecting the community from a repeat offender. Crucially, the judge added strict, non-negotiable conditions to all bonds, should he somehow manage to post them. He would be required to wear a GPS monitoring device and be under house arrest, forbidden from leaving without explicit court permission. Furthermore, the judge reinstated and clarified a no-contact order with the complaining witness, Jameisha Butler, making it clear that even communication through the jail's internal messaging system is a bond violation that will result in the bonds being raised even more. The judge delivered a stark warning. Continue this behavior and a jury will see it all, pushing him closer to that maximum sentence of 25 years to life for the habitual felony offense. This entire hearing serves as a chilling example of how a defendant's conduct inside the jail can severely impact the court's decision regarding their freedom outside of it. The judicial system is not a game, and disrespect for the process or for those who uphold it will be met with the full, unyielding force of the law. The final ruling locks Mr. Hancock up, prioritizes public safety, and ensures that the defendant will not have any unsupervised freedom, even if he posts the enormous bond. It's a complete win for the prosecution and a devastating loss for the defense, entirely driven by the defendant's own reckless actions.